Hi everyone, let's talk about constitutional law for business. In this lesson, we're going to describe the U.S. Constitution and the concepts of federalism and separation of powers. We'll define and apply the Supremacy Clause of the United States Constitution. We'll explain the Commerce Clause and the federal government's authority to regulate interstate and foreign commerce. We'll describe the Bill of Rights and the process for amending the U.S. Constitution. We'll explain the First Amendment, freedoms of speech and religion. We'll explain the 14th Amendment, equal protection doctrine. We'll explain the 14th Amendment, due process and takings clauses. And finally, explain the 14th Amendment, privileges and immunities doctrine. A lot of this is going to feel like a review of stuff you took in high school. If so, that's fine. We'll just go over some main concepts. So the United States Constitution sets up a form of government we call federalism, which means that we have one federal government and then 50 state governments that share powers. Some powers are enumerated in the Constitution, which mean they are given to the federal government. Powers that aren't enumerated or given specifically to the federal government are considered to be reserved for the state governments. The doctrine of separation of powers is evident in the Constitution because the Constitution sets up three branches of government. In Article 1, we set up the legislative branch, which is the part of the government that makes federal law, that consists of the Senate and the House of Representatives. Article 2 sets up the executive branch, which consists of the president and vice president and his cabinet. This is the part that enforces federal law. Article 3 sets up the judicial branch, which is the part of the U.S. government that interprets the law when there are questions about whether a law is constitutional or not. The Supreme Court and other federal courts are established here. It doesn't say exactly how many courts there have to be. It just gives the government the right to establish those courts. Checks and balances are evident in the Constitution, as each branch has some check on the other branches of government and balances where those other branches get to check that branch's power as well. The idea being that we don't let one particular branch of the government get too powerful. It's a constant struggle. As we're experiencing in these times here, there are a lot of questions about which branches of government should have which kind of powers and how much power and when is too much power. So we're always going to struggle with this. The Supremacy Clause of the Constitution establishes that the U.S. Constitution, federal treaties, laws, and regulations are the supreme law of the land. So if there are state and local laws that conflict with valid federal or constitutional law, they will be declared to be unconstitutional. Therefore, the federal law will preempt the state or local law. That's what the preemption doctrine is. It provides that the federal law takes precedence over state or local law. Sometimes Congress says that a federal statute exclusively regulates an area or activity. Oftentimes, local governments are also given concurrent powers. The way that would look is sometimes states are allowed to pass a law that would be more protective of people than the federal law does, but it can't be less protective than federal law. An example of that might be that there's a federal law establishing a nationwide minimum wage. States can go in and establish minimum wages that are higher than the federal minimum wage, but they can't establish, or rather they can't enforce a minimum wage that would be lower than the federal rate. A case regarding the Supremacy Clause that we'll look at is Mutual Pharmaceutical Company Incorporated versus Bartlett. This happened in 2013 and it went to the Supreme Court of the United States. The facts of the case are that the FDA approves a non-steroidal anti-inflammatory drug called Sulindac. The federal law is very strict on what pharmaceutical companies can put on drug labels. And so federal law requires sellers of Sulindac to use exact federally approved wording of side effects on the label. The required label does not include warnings about a rare possibility of a side effect called toxic epidermal necrolysis. Bartlett was prescribed Sulindac, which is manufactured by Mutual, and she experienced severe toxic epidermal necrolysis. Bartlett was in a medically induced coma for 6 months, had to go through 12 surgeries, and was on a feeding tube for 1 year. She is still severely disfigured and disabled. Bartlett sues Mutual in U.S. District Court for violating a New Hampshire labeling law for failing to warn her. A jury awards her $21 million. Mutual appeals to the Supreme Court of the United States, asserting federal law preempts New Hampshire law under the Supremacy Clause. So the issue at hand is, does the federal drug labeling law preempt a stricter state drug labeling law? The court decided that yes, when a state law would require a person to violate federal law, the state's law is preempted under the Supremacy Clause of the U.S. Constitution. It was impossible for Mutual to comply with New Hampshire's labeling law without altering the federally mandated label, so the state law was preempted. They also noted that they do have great sympathy for the defendant, but sympathy for the defendant does not relieve the court of the responsibility of following the law. It's a very unfortunate circumstance, but the court got it right. The Commerce Clause of the Constitution is extraordinarily important for business law. This is the clause that grants Congress the power to regulate commerce with foreign nations, among the several states, and with Indian tribes. The key clause there being among the several states. This gives the federal government the power to regulate interstate commerce, meaning any commerce that takes place across state lines or that affects people from other states, which gets interpreted pretty broadly to allow Congress to regulate just about any kind of business. The federal government has the power to regulate 3 types of commerce, listed just ahead of time, but most relevant to business law, Business 115, is that interstate commerce. During the formative years of the United States, the federal government regulated commerce with the Native American tribes. We entered into several treaties with many Native American nations and subsequently broke a lot of those treaties, unfortunately. We're still trying to figure out how to make up to those people. Native Americans are treated as domestic dependent nations with limited sovereignty, meaning there are still some Native American reservations scattered across the United States, and sometimes they're allowed to do certain things that other people wouldn't be allowed to do, chief among those being they have their own police forces most of the time, and they're allowed to operate casinos in a lot of places where gambling would otherwise be prohibited. The Foreign Commerce Clause grants the Congress the authority to regulate foreign commerce. That means direct or indirect regulation by state or local governments that burdens foreign commerce violates the clause and therefore would be unconstitutional. Interstate commerce is commerce that moves between states or that affects commerce between states. A landmark case challenging this was the Heart of Atlanta Hotel versus United States. This happened just after the Civil Rights Act of 1964 was passed, saying that everyone has the right to use public accommodations, the public accommodation here being a hotel. The Heart of Atlanta Hotel had a policy where they did not rent rooms to black people. The federal government said that they could no longer enforce that policy and they would have to allow black people as guests to the hotel. And Heart of Atlanta Hotel sued the United States, saying that the federal government doesn't have the right to regulate what they're doing. They claimed that they only had the one location there in Atlanta, Georgia, and that since they weren't involved in interstate commerce, they didn't have to follow the federal Civil Rights Act. In court, they looked at where the guests of the hotel come from. They decided that a lot of the guests come from out of state. Thus, they affect interstate commerce and gave the federal government the right to regulate them. So they could no longer say that they were not involved in interstate commerce, and they would have to abide by the Civil Rights Act of 1964 and allow black guests. The Dormant Commerce Clause. This is a situation in which the federal government has the Commerce Clause power to regulate an area of commerce, but has chosen not to regulate that area of commerce. States can still enact laws to regulate that area of commerce with its police power. The police power here being defined as power that permits states and local governments to enact laws to protect or promote the public health, safety, morals, and welfare. This is being tested quite heavily right now. Again, I'm recording this during the COVID crisis, and a lot of states, I'd say pretty much every state in the union, has passed some type of measure, oftentimes with an executive order, that says that certain types of businesses have to close or let their workers work remotely, and it puts restrictions on the degree to which people can go out and do things, how much space they have to leave in between other people, and a lot of things that are just very abnormal. And a lot of people question whether or not the states have the ability to do this. The states, of course, are arguing that this falls within their police power. Some people think that those restrictions are unconstitutional, and there is definitely some back and forth that's going to happen with this. We've already seen a couple of these work their way through the court system. Some laws being upheld, some being stricken down as being unconstitutional. So it is interesting times for us to test this, federal versus state power, and how much states can restrict activities, especially business activities. Also under the Dormant Commerce Clause, a regulation by a state should not unduly burden interstate commerce. An example we gave here was Michigan had a law that allowed their in-state wineries to sell directly to residents, but any out-of-state winery wanting to sell to Michigan residents had to sell through wholesalers, which would have made their wine more expensive comparatively. So they thought that as being an unfair competitive disadvantage, unduly burdening interstate commerce, and the Supreme Court agreed. We're all familiar with at least the concept of the Bill of Rights. It's the first 10 amendments to the United States Constitution. They guarantee certain fundamental rights to natural persons. They protect from intrusive government action by the federal government. Originally, it was only by the federal government. Later amendments to the Constitution also incorporated state governments into that. That's what we call the incorporation doctrine. So now we're protected from intrusive government action by both federal and state governments. Looking at the First Amendment, we find the freedom of speech fundamental to the United States way of life. That gives us the right to engage in oral, written, and symbolic speech, which is protected. There are different levels at which speech can be protected. Not all speech is protected all of the time. It's important for everybody to understand that. Fully protected speech cannot be regulated or prohibited by the government at all. This can be oral, written, or symbolic. Examples being criticizing the government, criticizing the president. A lot of people think burning the U.S. flag as protest is highly offensive. You might be right depending on your outlook, but has been ruled as being fully protected speech. The idea being that we should be free to criticize our government. That's not the case in every country in the world. There are a lot of countries where criticizing the government is the kind of thing that can get you thrown into prison or even killed. But we think it's very important as a fundamental protection here in the United States. People a lot of times will bring up a year or two ago, there was a controversy surrounding NFL players kneeling during the national anthem at football games as a protest for the way that certain minorities have been treated within the United States. And a lot of people took a lot of offense at that. And there were questions surrounding, can that kind of speech be limited? According to the First Amendment, the government can't go and lock those people up or force them to not do that. That would be fully within their First Amendment right to do that. The bigger question at hand was, should the individual teams be able to restrict that? And the answer is yeah. If you're working for an employer then there are a lot of ways that your employer can restrict your speech, more so than the government would be able to. And if you didn't like it, I guess you could go find another employer. So some teams passed rules saying that the players couldn't do that. Some teams allowed their players to do that. We probably haven't seen the end of that controversy. Some kind of speech not being fully protected is considered to be limited protected speech. This is speech that is subject to time, place, and manner restrictions. So it has to be at the right time, in the right place, and in the right manner. So speech that is considered to be offensive. Now, offensive speech is always going to be very relative. Is going to depend on, what year is it, what kind of speech is it, who's listening to it, regarding, who considers it to be offensive. But it's always going to be controversial because certain people think speech is offensive, where other people might not think it is. But if we find that the majority of people out there think that a certain kind of speech is offensive, then we might subject them to time, place, and manner restrictions. For instance, if you're watching TV, there are certain words that are not allowed to say before a certain time at night. I think it's 10 o'clock maybe, when they are not allowed to say certain words that people think are offensive or profane. But then after that, they could use those words, whether they choose to do so or not. Just depends on the individual companies. And that's for the general broadcast media, not for cable channels. Speech used by business is also considered to be limited protected speech, such as advertising, billboards, certain things that the general public would deem to be offensive or profane or something like that, would be limited to time, place, and manner restrictions. Some speech is just not protected at all. So they can be forbidden. This would not be considered to be a restriction of First Amendment rights. So certain speech that is viewed to be eliciting violence or inciting riots or child pornography is not protected at all, and you can't use that as an excuse. So a case that tested this very recently, and in North Carolina, was Packingham versus North Carolina. This happened in 2017 in the Supreme Court of the United States. The setup is that North Carolina enacted a criminal statute that prohibited registered sex offenders from accessing social media sites where the offender knows that minor children can have accounts to access that particular social media. So Packingham was a registered sex offender. He was living in North Carolina at the time, and he started posting things on Facebook 8 years after his conviction. There was no evidence that he contacted a minor or engaged in any illicit acts. It doesn't appear he was doing anything bad here. But since he did post on social media, he was indicted in North Carolina for using social media in violation of state law, since he was that registered sex offender. Packingham claims that the North Carolina law violated his First Amendment rights to free speech. Packingham is convicted in North Carolina court, and the North Carolina Supreme Court affirms that conviction. He appeals out to the Supreme Court of the United States. A lot of times you'll see me abbreviate that as being SCOTUS. It just stands for Supreme Court of the United States. The issue here being, does North Carolina statute that prohibits registered sex offenders from using social media websites violate the First Amendment? The Supreme Court, looking at it, said yes. Their reasoning is that social media sites are important places for the exchange of views. To foreclose access to social media altogether is to prevent the user from engaging in the legitimate exercise of First Amendment rights. So they said the North Carolina law is too broad and must be held to be invalid. So then that kind of begs a question. I guess the intent of North Carolina at the time was to try to keep registered sex offenders from being able to contact minor children over the internet. So is there a way they could have worded the law differently to still protect those minors, but not to unconstitutionally limit people's freedom of speech? Maybe they could have. The wording would have had to been much more limited. Maybe they could have been allowed to post on Facebook, but they couldn't contact anybody under the age of 18 or something like that. But that's just not how it turned out. Then we turn to, still in the First Amendment, we turn to the freedom of religion. So there are two parts to this. There's the Establishment Clause, saying that the First Amendment prohibits the government from either establishing a state religion or promoting one religion over another. The reason this exists in the Constitution is that the United States was created out of rebellion against the British form of government, where religion was heavily intertwined with the government, and a lot of people thought that was not a very good idea or a very good way to run a government. There were a lot of abuses that took place, so they tried to keep that from happening in the United States. So we can't establish a national religion. States can't establish state religions. We can't be seen. The government can't be seen as promoting one religion over another one. Because that would lead people to think that there was indeed a state religion. The Free Exercise Clause says that the government can't prohibit people from the free exercise of their religion in the United States. So the government can't establish a national or state religion, and the government also can't prohibit people from the free exercise of their particular religion. There's always going to be people testing the boundaries of this. The right is not completely absolute. For instance, we found it to be illegal to allow the so-called snake-handling churches of Appalachia from allowing people to pick up and handle these venomous snakes in the church services. However, there's one of the big religion test of religious freedom now has to do with maybe a teacher at a Catholic school comes out as being gay, and the Catholic school fires them. And let's assume that in that state, gay people were protected from being fired just for being gay. Would the church be able to fire them? So we have a clash of rights. One is the religion's right to run the church how they see fit. They call that the ministerial exception to employment laws. Versus the rights of the teacher to have a job and not be discriminated against based on their sexual orientation. So we see a lot of that kind of case happening nowadays. The equal protection, we're switching gears now to the 14th Amendment. The 14th Amendment contains several very important protections. One is the Equal Protection Clause. This says that a state cannot deny to any person within its jurisdiction the equal protection of the law. So the laws have to apply to everyone equally. We can't say that a law applies to certain people one way and certain people another way. This, again, being a reaction to some of the unfortunate parts of United States history where there was a lot of racism or prejudice based on other characteristics. The Equal Protection Clause also covers artificial persons, such as corporations. So you and I, actual living, breathing people, we would call natural persons. There are artificial persons like companies, corporations that have similar rights to a natural person. Not always the exact same rights, but a lot of the same rights to speech and things like that. But the 14th Amendment, the Equal Protection Clause, doesn't make the classification of individuals unlawful. It says that in most cases we can't apply laws differently to different people. If we have a law that appears to treat people differently, there will be different standards of review that a court will apply based on what kind of difference there is. So these are the standards of review. It means just the way that a court is going to look at how strictly are they going to interpret the constitutional protection related to this kind of law. So the most strict one is called the strict scrutiny test. This test is applied to determine constitutionality of classifications by the government based on a suspect class. The examples we give are race, national origin, religion, or citizenship. They're a suspect class because just because the United States would have a history of discriminating based on these things. So we're trying to keep that from happening anymore. And it also would have to involve a fundamental right. So it would have to involve a suspect class or a fundamental right. Fundamental rights there's a lot of them, but things like the right to vote, the right to get married, the right to privacy, the right to use contraception, to procreate, to travel interstate would be considered to be fundamental rights. So if we have a law that treats people differently based on a suspect class or based on a fundamental right, the court is going to look at that very carefully. And if the law is allowed to stand, they would have to prove that the law serves a compelling government interest. It has to be narrowly tailored to achieve the government interest, and it has to be the least restrictive way to achieve that government interest. Backing off strict scrutiny, we have the intermediate scrutiny test. This would be applied to classifications based on protected classes, an example being gender, and First Amendment issues. So some examples here being the military draft has historically treated gender differently because males have to register for the draft, whereas females do not. Highway signs, looking at the way that businesses would advertise or put things on signs, that would have to do with a First Amendment issue. So if there was a challenge to whether or not somebody was allowed to put something on a sign, we would have to say, well, is the law that's restricting that speech, is it furthering an important governmental interest, and does it do so by means that are substantially related to that interest? Okay, this is all language that's come out of court cases. There's not always a clear line between whether or not something should qualify for strict scrutiny or intermediate scrutiny, but we can use this language in court trials to try to decide whether or not it applies for one test or another. Whether or not a law would apply for strict scrutiny versus intermediate versus rational basis can have a huge effect on whether or not a law is going to be able to stand. The least restrictive test being the rational basis test. This applies to classifications not involving a suspect or protected class, an example being age. So the court will uphold a government regulation under the rational basis test so long as there is a justifiable reason for it. This permits a lot of governmental regulation of business. So an example here being that we can have laws saying that you have to be a certain age before you can start getting Social Security benefits. There's a justifiable reason for it because as people get older, they become less and less able to work, but they also need to have some kind of stable income to keep living a certain standard of life. So that would be a rational basis allowing that kind of law that would treat people differently based on age. Still in the 14th Amendment, the Due Process Clause. This says that no person shall be deprived of life, liberty, or property without due process of the law. Under the 5th Amendment, that would also include federal government action. So when we combine the 5th and 14th Amendments, we get protection from both federal and state and local government actions. The government is not prohibited from taking a person's life, liberty, or property. That's pretty important to note. It just says that they have to follow due process in order to do so. There are a couple different kinds of due process. One is substantive, the other is procedural. Substantive due process requires government statutes, ordinances, regulations, or other laws to be clear on their face and not overly broad in scope. They would be tested using a reasonable person's understanding of the law. Laws failing that test are declared void for vagueness. So this prevents overly complex or vague or just hard to understand laws. A reasonable person should be able to understand it. If they can't, then that would violate substantive due process. Procedural due process requires the government to give a person proper notice and hearing of legal action before depriving that person of life, liberty, or property. In other words, you're supposed to have your day in court. You're supposed to be given notice about the legal action being taken against you, given the opportunity to defend yourself in a court of law. An example case here for due process and equal protection is Obergefell versus Hodges. This happened in 2015 in the Supreme Court of the United States. The facts are that several states had laws defining marriage as being between one man and one woman. They refused to recognize same-sex marriages, meaning they would refuse to perform in their states, and some states even would not recognize same-sex marriages that had happened in other states. Many plaintiffs in several states brought lawsuits challenging these laws as being in violation of their 14th Amendment rights of due process and equal protection. Along the way, the cases were consolidated and appealed to the Supreme Court of the United States. The issue here being, do the challenged state laws violate the 14th Amendment due process and equal protection clauses? The court said, yes, they do violate them. They said that the right to marry, they declared marriage as being a fundamental right inherent in the liberty of a person. They said that under the 14th Amendment, couples of the same sex may not be deprived of that right and of that liberty. And the petitioners asked for equal dignity in the eyes of the law. The Constitution grants them that right. By the way, North Carolina was one of those states that they both had a law on the books saying that same-sex marriage was illegal. They also passed we also passed a constitutional amendment to our state constitution defining marriage as being between one man and one woman. If you look up the state constitution, you'll still see that amendment in there, and if you look up the state statute, you'll still see that state statute in there. However, even though that amendment and that statute still exist, they at the current moment cannot be applied or enforced because the Supreme Court found them to be unconstitutional. Government takings under the 14th Amendment. So a government can't take a person's property without just compensation. Now, there are times when the government will be allowed to take your property for public use. This is called eminent domain. But there are going to be restrictions on the circumstances that have to be in place for the government to forcibly take your property. And if they do take it, they have to provide just compensation. In other words, you have to be paid for it. A case here involving the takings clause is Horn versus the Department of Agriculture. This happened in 2015, and it did go to the Supreme Court. The facts of the case are that there was a raisin committee, which was part of the USDA, the federal government, that enforced a reserve requirement that required raisin growers to turn over a percentage of their crop to the government free of charge every year. That percentage could be quite high, in the order of the mid-30s to the mid-40s percent of their crop being turned over to the government without any compensation. The justification being that they established a strategic raisin reserve. The government can use those to trade with foreign governments. They can use it to give away to charities to help secure the food supply in the United States. In 2002, the Horns, which were some raisin growers, they just refused to turn over any raisins to the government. The government then assesses fines of $480,000, which would have been the market value of the raisins they were supposed to turn over, and an additional $200,000 for disobeying the government order. The Horns sue, claiming that the government's order was an unconstitutional taking under the Fifth Amendment. The issue here was, does the government's action constitute a taking of personal property under the Takings Clause of the Fifth Amendment that requires the payment of just compensation? The court said yes. The government has a duty to pay just compensation when it takes your property, whether it is real or personal property. The government had a couple of arguments here, saying that the Takings Clause doesn't apply to personal property, it only applies to real property. The Supreme Court didn't agree with that. They also said that it didn't count as a taking because the raisin growers could have chosen to grow anything else if they wanted to, and if they had grown anything else, the government might not have taken that. And the court also didn't agree with that reasoning, so they were forced to then pay the raisin growers for any raisins they took. The Privileges and Immunities Clause of the 14th Amendment says that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. This means that no state can make or enforce a law that shall abridge the privileges or immunities of the citizens of the United States. The clauses prohibit states from enacting laws that unduly discriminate in favor of their residents. So an example being that North Carolina couldn't pass a law forbidding residents of other states from owning property in North Carolina. We couldn't pass a law saying that residents of other states couldn't operate businesses in North Carolina. That would just be a violation of the Privileges and Immunities Clause. The clauses do apply only to citizens and do not protect corporations or aliens. That's it for this lesson. I hope you all have a great day.